You're hearing USCIS is speeding up, yet your worker petition just slowed down while your friend's N400 finished in record time. The split is real. Citizenship and many I-485 adjustments of status for green cards are moving very fast. But I-129s jumped 80% plus year over year, and consular queues still add months, all alongside a record backlog and even unopened filings at intake. If you plan off headlines instead of your form and office, you risk requests for evidences, missed travel, or an all-out denial. Hi, I'm immigration attorney Zaira Solano with over 13 years of experience in immigration, and this video, I'll map what's actually faster, what actually isn't, so you can choose the correct process, avoid unnecessary delays and denials, and keep your job offer, status, and family plans intact. Let's jump right in. You deserve the truth, not headlines. Some immigration processes are moving faster right now, but the shift is selective. Citizenship is the clearest example. National medians for the N400 citizenship application are the quickest since 2016. And many offices are deciding naturalization is roughly 5 to 6 months when files are complete and background checks are clear. Those numbers track the Federal Historic Processing Table published through June 2025 and match independent summaries of current medians across field offices. Family and employment-based green card cases show a more nuanced picture. Inside the United States, family-based adjustment of status is commonly just over 8 months when visa numbers are available. Employment-based adjustment of status lands near 7 months when filings are clean and well documented. Fiancé petitions are running closer to 8 to 11 months, and consular queues for cases abroad at U.S. embassies and consulates around the world add more time after USCIS approval depending on your location. These are medians, so half of the cases are faster and half are slower, which is why your service center and your field office still matter a great deal. Non-immigrant worker filings are the outlier. Median processing times for the I-129 rose sharply this year. Analysts comparing Q2 of fiscal year 2025 with the prior year report an increase of more than 80%, even as the associated backlog fell. That pattern suggests staffing shifts, triage choices, or added review steps are reshaping how quickly these petitions move. Premium processing still helps in eligible categories, but the baseline is longer for many employers who are not paying the upgrade. Here is the catch that should guide every decision you make. The overall USCIS pending caseload reached a modern record in Q2 of fiscal year 2025, with roughly 11.3 million cases waiting for action after completions dropped compared with last year. USCIS acknowledged a front log of unopened filings, a signal that intake itself is strained. At the same time, the immigration courts are carrying millions of matters, with asylum making up a large share of the docket. From a client perspective, that means that faster results in some lanes are happening alongside rising pressure elsewhere. So your strategy must be calibrated to your specific category and office. Keep your eyes on the numbers, not rumors, and plan accordingly today. Why now is the question every client asks me. Inside the agencies, the answer starts with the hard targets and public accountability. USCIS set internal cycle time goals in 2022 to push decisions out faster and reported visible progress in 2023, including major gains in naturalization completions and a first net backlog reduction in years. Those targets did not vanish with changing leadership. They still shape staffing, overtime, and triage, and they are the reason some forms are being driven towards short, predictable timelines again. Technology is the second driver. DHS and USCIS have been testing artificial intelligence to triage documents, detect fraud patterns, and assist with intake, which allows straightforward files to move quickly while unusual files are held for officer review. AI pilots and an agency use case inventory describe how machine learning can accelerate screening and speed investigations by orders of magnitude when deployed responsibly. That produces faster decisions, but it also increases the risk that rigid modules will miss nuance unless a trained adjudicator slows down and checks the record. Policy choices after January 2025 are the third driver. The administration has linked employment visas to labor priorities and announced measures that raise costs and limit entry for certain non-immigrant workers, framed as protecting wages and jobs for U.S. workers. A recent White House proclamation restricted entry for categories of non-immigrant workers and justified higher costs as necessary to curb abuse. Days later, the White House clarified that a new one-time fee, $100,000, applies to new H-1B petitions going forward, not to the existing holders, which immediately changed the economics for many employers. Court pressure is the fourth driver. The Administrative Procedure Act requires agencies to conclude matters within a reasonable time, and immigrants have increasingly turned to federal courts to challenge years-long delays. Judges apply the track factors from Telecommunications Research and Action Center versus Federal Communications Commission to decide if delay is unreasonable, and agencies that lose those cases face orders to act. The Supreme Court's decision in Loper-Bright overruled Chevron deference and signaled that courts will not reflexively accept agency interpretations. Less deference plus more mandamus suits means more risk, and the risk pushes agencies to move cases faster. Pressure across agencies is real. Speed can create error. Automation is excellent at flagging missing documents, but it's not excellent at weighing credibility, context, or complex legal standards. Immigration lawyers report surges in requests for evidence and sharper denials, even where filings are thorough, which raises costs and forces front-loaded proof. When a machine or template drives the first pass, nuance is easy to miss until an officer slows down to review the record. This is why you will hear me say that faster is not always safer when your status is on the line. The second danger is how speed connects to enforcement. The administration has emphasized deportations and removal flights at a scale not seen in so many years. DHS recently announced more than 2 million people leaving the United States through deportations and self-departures in under 250 days. And immigration courts are signing tens of thousands of deportation orders every month. August 2025 data shows more than 65,000 deportations completed, with a large majority ending in deportation or voluntary departure. And advocates tracked hundreds of deportation flights in a single month. Faster case handling can become a pipeline when the goal is throughput. The danger is uncertainty for people with strong cases who simply fall into a deprioritized lane. When resources shift, some categories speed up while others slow down. We have already seen I-129 non-immigrant worker processing times jump more than 80% year over year, while other forms move faster. Fiancé and consular cases can still wait months after USCIS approval because overseas posts are reassigning staff. If your family or your business relies on predictable timelines, those swings are not abstract. They reshape budgets, job offers, and travel plans. The final danger is legal exposure when denial leads straight to enforcement. Expedited deportations limit the ability of many asylum seekers to ask a federal judge to review what went wrong, a limit the Supreme Court upheld in the Thuraissigiam decision. When hearings and screenings move faster, a mistaken finding can snowball into detention or removal before counsel can build a record. That is why preparation, counsel, and documentation matters more as the system accelerates. Speed raises the stakes, and the law often gives very little time to correct a bad decision. Treat speed as a tactic, not a promise. Start by checking the official processing time tool for your exact form and office, then build a timeline for your case instead of copying a friend's experience. The page shows the median and the date when a case becomes outside normal, which tells you when to ask USCIS for help. Accurate forms, organized exhibits, and credible third-party evidence are your best defense against automation errors and snap judgment. budget for fees, and understand why they exist. Congress allows USCIS to recover the full cost of services under Section 286M of the Immigration and Nationality Act. That authority drove the 2024 fee rule and the $600 asylum program fee. The White House also clarified a new one-time fee of $100,000 will apply to new H-1B petitions, which changes hiring math overnight. Plan early, explore alternatives, and do not wait to adjust offers. Have a plan to escalate. If your filing slips past a normal window, use the receipt date for a case inquiry on the USCIS website and open up a service request. If a denial misses the law or the evidence, decide quickly whether a motion, an appeal, or a refiling is best. When a case languishes unreasonably, the Administrative Procedure Act lets you ask a federal judge to compel action, and courts use the track factors to decide those suits. After the Supreme Court's Loper-Bright decision ended Chevron deference, a well-grounded challenge can carry real weight. Before we wrap, here is the takeaway. Some timelines are improving. The speed is selective, and it is driven by technology, politics, and litigation risk. That speed can help or hurt depending on your preparation. Next, we will unpack the change, reshaping, skilled hiring this year. The next video is about the H-1B visa $100,000 fee, which I explain, and I give 5 ways to work around that. It explains what the fee means, who it touches, and practical strategies to protect your hiring or your career. If any part of your plan touches the H-1B space, this video is essential to protecting your rights and your case. I'll see you over there.